Tesla's board of directors awarded Elon Musk, the world's richest man, a $56 billion, yes, with a B, billion-dollar pay package. It's the largest in corporate law history, and although a supermajority of shareholders approved this pay package, one shareholder named Tornetta sued to stop it. Now look, these kind of suits happen all the time, but this time a Delaware court agreed the pay package is improper. And this is actually really weird, because in corporate law, courts defer to board decisions and shareholder votes. The decision set off a firestorm in the corporate world. Is this a legal decision that is a triumph for governance and accountability, or is this the end of shareholder democracy as we know it? Did the Delaware courts go too far, or not far enough? Today we're diving into Tornetta v. Musk, a case that could reshape the future of corporate governance and unseat Delaware's dominance. Welcome to Organized, the business law breakdown. I'm your host, Professor Seth C. Oranburg, a business law scholar at the University of New Hampshire, Franklin Pierce School of Law, and a director at NYU's Classical Liberal Institute. Joining me today are two exceptional colleagues. First, Professor Anat Alon-Beck, a recently tenured full professor at Case Western Reserve University School of Law, who is a leading voice on corporate governance and shareholder lawsuits. Anat, welcome.
Thank you so much, Seth. I'm so thrilled to be here with you. And this case isn't just about Musk's pay package. It's really about power, accountability, and what it means to govern responsibly.
And we're also joined by Professor Eric Chaffee, the Peter M. Gerhardt Distinguished Research Scholar at Case Western Reserve University School of Law. Eric is a nationally recognized expert in business law, corporate governance, and state competition for choice of law. Eric, it's an honor to have you here as well.
But thanks for the kind introduction. Big fan of your work as well. I think this is going to be an absolutely fabulous conversation about really interesting issues of Delaware law.
Anat, let's start with basics. What was Tesla's board trying to achieve with Musk's compensation package? And why did courts get involved?
Thank you so much. This is a great question. And so really, this case, the Musk versus Tornetta case, revolves around, like you stated, Elon Musk's 2018 compensation plan, and he still is, by the way, Tesla's CEO, right? And this compensation plan could award him up to $55 billion if certain performance milestones were met. And the shareholders approved the plan, but Tornetta, who is a Tesla shareholder, challenged it in court. Tornetta basically alleged flawed disclosures and procedural deficiencies in how the board approved the plan. And there are several issues. I'll just highlight three of them, kind of, high level. One, board independence. There are questions about whether Tesla's board and the compensation committee, whether they were independent enough from Musk to fairly negotiate and approve such a substantial package. Two, think about disclosures, right? Disclosures to shareholders. The court here found that some critical information regarding how this compensation plan was designed and approved may not have been adequately disclosed to shareholders before their vote, because we want them to be informed. And the third really main issue is the procedural flaws here. There were many concerns about whether the process that was followed by Tesla's board and the board's advisors ensured fair treatment of shareholders and prevented Musk's outside influence. Because we have here a superstar CEO that we all know, as valuable as he is, he probably also has a lot of influence over the board. And then the Delaware Chancery Court examined these factors closely to assess whether this compensation plan meets the rigorous standards for executive compensation under Delaware law.
Eric, some listeners might not know all of the corporate law ins and outs that impact this case. And from what I heard from Anat, this touches on some legal requirements for paper and process, procedure. Some people might think that's kind of ticky-tack stuff. This is really just a check the box exercise, or I mean, what's really at stake here when it comes to the corporate law? Do you have some perspectives on how to simplify some of the corporate law that underlies the issues that got brought up here so that people can follow along with our discussion a little better?
Yeah, that's a great question, Seth. I mean, the default is the business judgment rule, this business judgment presumption that most courts use that essentially managers of corporations ought to be able to manage. And courts not going to second guess them. Courts not going to second guess them basically when they make management decisions, even if they are bad ones. That being said, I mean, you have to police corporate management's behavior. Power corrupts and absolute power corrupts absolute. That old John Acting quote. And the idea is that we can do that through various fiduciary duties, the duty of care, which requires you to inform yourself, the duty of loyalty, which requires you not to steal from the corporation that you're a manager of, the duty of good faith, which requires you not to act reprehensibly, and the duty of disclosure, which requires you to disclose things so that are germane or relevant to the business. Here, Elon Musk basically has been accused of and found guilty by a court of violating various duty of loyalty concerns. And he's not actually stealing, but the idea is that the duty of loyalty extends to things like taking advantage. Can he potentially get this type of major compensation project? Can he get this type of major compensation package? Yes. But the Delaware court wanted him to prove the entire fairness of the transaction, fairness in terms of the price that he was receiving, the dealing in terms of entering into this deal. And at least according to the Delaware court, just didn't do that. Ultimately, when that was discovered, the court said, well, we're going to undo this deal. We're going to rescind this deal. And the response of Elon Musk and his legal team was to say, well, we're going to seek ratification, a vote from the shareholders that say that this huge compensation package is okay. And the court said that that just didn't procedurally work, that it was too late, that it should have been raised earlier, that the shareholders can't ratify this type of exorbitant package. That ultimately this just simply was not effective here in this particular case, especially because there were concerns about the toxin materials actually to solicit the shareholder vote.
Okay, so I think I get what's at stake here. From a legal basis, we have this idea of the duty of loyalty, that the CEO has to be loyal, and that doesn't mean just not stealing, but you can't take advantage of a corporation you run. You're kind of a fiduciary. You have some responsibilities. And part of that responsibility is to follow certain processes because it's the process itself which creates the fairness. But there's also maybe this idea of entire fairness where the results or substantive fairness also matters. So it does seem like there's a couple different kinds of fairness here. And what I can see from the case is at least some people thought both the results and the process were objectionable, that were unfair. And 56 or $55 billion, that's a lot of money. So maybe that's why this one really lit up my inbox. But I want to really get into why corporate lawyers and some academics are so worked up about this case. I mean, yeah, the richest man in the world gets a little richer or not. Like, that's kind of a not my problem kind of thing. But people are making this out to be like this is a alarming shift in law that could change how corporations function in America. This is a really big deal. And in fact, some have argued that this gives judges too much power because like you said, we have this business judgment rule, which incorporates the idea of deference to corporate boards when they make decisions. And corporate boards did make a decision and it didn't stick because the judge said so. And then the shareholders did vote to approve the pay package. And then the court again said, nope, too bad. It wasn't approved good enough. How do you, Eric, respond to the idea that this ruling is overreach? And I just invite here for you to kind of just play along with the devil's advocate point, because like the Wall Street Journal editors board basically said, the sky is falling, corporate democracy is over. Is that true?
Yeah. So it's one of those things where, ultimately this is a very interventionist opinion by the Delaware Chancery Court. They're making a decision about what sort of compensation that Tesla should be able to award its CEO. They're making decisions about whether or not the board here, in fact, is making a reasonable decision. And we have that really, really strong business judgment presumption out there in the world that courts shouldn't be second guessing what's going on within a corporation because, they're not business experts. They don't have the same sort of knowledge that a board has. They're not the ones who are authorized. And the idea here is that, ultimately in regard to this case, that there are real concerns about how much the court is getting involved. That being said, I mean, on the other side of things, ultimately, there has to be somebody who watches the board. There has to be certain sorts of transactions that are of concern, certain sorts of transactions that, in fact, should be policed by courts. In regard to this case, what we're seeing is essentially a court saying, first off, we don't think that this amount of money was justified, this $56 billion that was authorized to Elon Musk in terms of the compensation that he was going to receive. And then second, in addition to that, he just didn't do the procedure right. And it's one of those things where everybody enjoys a good game of tennis. Tennis isn't fun when you start playing without a net. It's not fun for the spectators. It's not fun for the people involved. It might be fun for the winner, but at the same time, you're not playing the games by the rules that you really ought to be.
Okay, so this is about rules as much as anything else. And, hey, I teach contract law. I love rules, rules for rules' sake. And can we talk about this a little more? I mean, are these rules really important rules, or is this, how do these rules relate to this idea of shareholder democracy? So maybe we can talk a little bit about that idea, but, shareholders own corporations, and kind of like how citizens have representatives in government because we vote, and then our representatives take actions on our behalf to run our government. Shareholders, they vote for directors, and the directors take action on their behalf. And this is supposed to be a good thing. And here the shareholders apparently approve the package, at least according to some arguments. Why should a court ever question what shareholders do? Why are these rules important? Because if we allow courts to kind of penalize shareholders because of some minor technical violation, then we don't really have democracy at all.
Thank you so much for this question. I think it's very important, and I completely understand some of the outrage, right? You talked about the Wall Street Journal, other commentator. Just check out my, X or Twitter or LinkedIn page, and you'll see the types of comments I'm getting from colleagues, from people in our field, right? Pushing back against what's going on. And I always say, hey, don't shoot the messenger. Let's just talk about a little bit about the rules, about what do we care about when we talk about procedural integrity and what's really going on here. So what I'll do is I'll kind of set the stage. I'll talk a little bit about, again, the key issues, like the key governance issues, and then what happened with regards to the shareholders, to kind of set the stage and explain to our listeners, why are we even having this issue if the shareholders voted? And that's what people tell me. They're like, Anat, the shareholders voted. So first of all, we're not talking about a regular case, right? We have Musk. Musk is the largest shareholder of Tesla. He's a highly influential figure. And that raises unique governance concerns, right? Why? Because Musk has outsized role in the company's operations, in the decision-making, and also the company's public image influences all of that. And again, think about the following. We're talking about his compensation package. And executive compensation, as you know, is already such a challenge and controversial issue with regards to corporate governance. Now, we're talking about, by the way, compensation package that offered him up to, $56 billion, which, by the way, today I'm told it's actually over $100 billion. Okay, we're talking about a lot of money. Now, while you are correct by saying, well, shareholders approved this plan and it was challenged. So why? Let's first understand why it was challenged and what happened with the second approval, okay? So let's talk about the first one. So the first one was challenged on the grounds that Musk is a dominant, again, figure and especially due to his position as a CEO, he's de facto leader. And perhaps because of this, you know, control over the company, we'll talk about it in a second. What does it mean to be a controlling CEO? That can compromise the board of directors' independence and overall the procedural integrity of this approval. And so first, let's talk about three things. First, controlling CEO, right? So Musk's influence over Tesla's board and the executives blurred the lines between oversight and leadership, right? That's the concern, that he has a dual role. He's a shareholder on the one hand, and then also a CEO on the other. And that raises the concern about whether the board could independently evaluate and approve such significant compensation package. Okay, so that's the first issue that the court had to deal with. Second, the procedural integrity. Governance, good corporate governance requires boards of directors to adhere to strict processes. Yes, we have processes. That's why Delaware law is so efficient. That's why, if you're like me, if you believe in law and economics and you want to reduce transaction costs, you actually adhere to these processes, which are very strict in Delaware. Why? We do this to protect shareholders, especially when we're talking about a situation where a board needs to approve compensation for a very powerful, a star CEO. And so the Delaware court is scrutinizing whether the Tesla board and Tesla's compensation committee acted independently, hired unbiased advisors, whether they thoroughly documented the decision-making process and said, I love it, I use it in my classes as well when talking about the paper and process, right? Did they follow the proper procedures here? And the third overarching issue is really the disclosure. And I'll talk about that with regards to this first approval and then the second. And that is, did the shareholders receive clear, comprehensive information before voting on major decisions? And throughout the cases, by the way, with both of them, there were allegations of incomplete or misleading disclosures. First, about the plan's development and approval process, and that called into validity, right? Was the shareholder vote? Did the shareholders really voted? Did they understand what they're voting on? Were they informed? And this is with regards to really the procedural integrity here. We want to ensure fair corporate governance. And for companies, and there's other companies that are led by visionary leaders like Musk, it's critical to maintain strong, independent boards that could really have these checks and balances. They could check executive influence. They could provide accountability. They can safeguard shareholder interests. And so the court's findings here on this case are going to set the stage to broader precedents, right? This is something that Delaware is known for, and that it's legal precedents. And that's so important for how other companies, not just Tesla, are going to balance these types of innovative leadership on the one hand, but we also want to have robust governance frameworks, and we want to protect shareholders. Now, we also talked about, I promised I was actually going to talk about the second approval, right? And I want to talk about something very important, and that is the timing of the ratification. There was a fatal flaw there.
I just want to bring in too, because some listeners don't know all the terminology. Ratification is an approval that relates back. So it's approving something that happened in the past. So the pay package was technically already approved, right? And then can you just lay out the timing of this? Because I think that's gonna matter here.
Absolutely, because timing was so essential here. And so what we had the Tesla shareholder vote, and then there was another vote that was held after the trial, okay? This is after the trial, yes. So think about the following. Less than an hour after the Delaware court issued its post-trial opinion, Elon Musk then went on Twitter, X today, criticized Delaware on social media. Then 7 hours later, he announced plans for Tesla to immediately hold a shareholder vote to transfer its state of incorporation to the state of Texas. So basically, to take Tesla, which was a Delaware company, to Texas. And then he asked the shareholder to vote on two things. One is to move the company from Delaware to Texas, and two, to again go back and approve that same compensation that was already approved, to vote on it again after the trial. And Tesla's board quickly acted on Musk's proposals. They formed a special committee on February 10th, by the way, to evaluate these moves. And by March 5th, the committee's mandate was expanded to include determining whether the compensation package should be ratified alongside the what we call redomestication vote, right? And that is, again, to move the company from Delaware to Texas. So going forward, Texas law would apply. And then, again, let me just say one more thing about conflict of laws. That's only for future litigation, okay? You can't move an existing issue out of the state because the court already made these decisions. I think it's important. Some people don't understand that. That's very important. And by the way, if you look at who's sitting on this committee, even the composition changed because initially we had Kathleen Wilson-Thompson and Joe Gebbia, and then he left and she was left there by herself. And so, again, the issue here, and that's why people were left with kind of, if you follow corporate governance, kind of a bad taste in your mouth, okay? The issue was the fact that it was done after the trial. And so it looked like a maneuver to undermine judicial integrity. That was the issue. That's why people had really hard time.
Well, it's kind of like the tennis analogy here because it's sort of like, hey, I don't like the rules for your tennis match, or I don't like the referee, so I'm going to take my racket and my balls and go play somewhere else where I get a different advantage because, you're almost threatening the courts here. I mean, this is definitely not the usual case. And you made that point loud and clear, and now I see it because, I mean, sure, Elon Musk is not the usual guy, right?
Right.
He's not the usual CEO that also wants to colonize Mars and become part of the federal government and all these other things that are happening. But he literally, as you say, like threatened the court and threatened Delaware and maybe threatened Delaware's standing. So I want to turn back to Eric and bring him into this part of the conversation because, maybe people don't realize why Delaware would feel threatened because it seems like all the major companies are in Delaware. And it's just sort of obvious that, Delaware is where you are incorporated. And just so people know, the way that corporate law works is that the rules that apply to your internal affairs, like compensation package and stuff like that, they're based on what state you incorporate in. And, you might think you have to incorporate in the state you live in, but that's not true. Anyone can incorporate in any state, in any jurisdiction. And in fact, you can reincorporate, you can move. And Anat was just talking about how basically, after a judicial decision that he didn't like a spoiled child who was threatening to take his toys and go play somewhere else, Elon Musk is going to leave Delaware and go to Texas, where he's going to get, better rules. So this actually does seem like it's an interesting way to threaten the courts and basically say, courts, if you don't act in favor of managers are going to take their toys and play somewhere else. And by the way, it's really not the toys. It's really the tax dollars that matter. Delaware makes its money with two things, corporate taxes and that bridge. That's about it. That's about Delaware's. No, really, you can look at the reports. That's about Delaware's entire revenue. They have a fairly profitable bridge and a lot of corporate tax revenue. So it's really important to Delaware to have attractive corporate law. So Eric, does this mean that Delaware's dominance is threatened? Or does something else happen here that actually shows that Delaware is maybe even more valuable than ever? What's your take on it from that kind of choice of law perspective?
Yeah, that's a great question. Ultimately, Delaware is the dominant jurisdiction for incorporating, and there's a question as to why. And there's a debate over that in regard to corporate law. Some people claim that essentially it is a race to the top, where Delaware produces very high quality corporate law. Some people claim that it's a race to the bottom, where Delaware basically panders to management. I actually think that this is a race to the top. What Delaware does and what it does well is essentially balance a full bunch of different interests. It balances the interests of management, balances the interests of shareholders, it balances the interests of the public, and it tries to do that in an efficient way through creating rules that make a sensible system. And the nice thing about how Delaware, if you incorporate there, unlike some other jurisdictions, you know pretty much what the law is going to be. The problem with this case, and really why everybody's talking about it the way that they are, first off, people are just interested in Elon Musk because he's an interesting human being. But second, it's a shock to the system. There's a surprise here where it seems like shareholders ought to have a lot of power in terms of how their money, their resources are distributed. And the question becomes, well, what are the limits to that power? What are the circumstances where they're allowed to ratify a decision, ratification occurring essentially after a transaction occurs and approval occurring prior? At what point do they really have a meaningful say in where their money goes?
Right. So there's a tension, right? Because as you point out, there's lots of people in the corporate drama. You've got managers and managers make these day-to-day decisions, but they're supposed to do so on behalf of shareholders who are the owners. And shareholders themselves may have different interests. There are shareholders that are in it for the long term. There are shareholders that are in it for the short term. I mean, there's that guy on Robinhood who's buying and selling something every 14 minutes. And there's my grandpa who bought Comcast when it went IPO in the 40s and died with stock certificates under his bed, like literal stock certificates. So they have very different interests. And how do you balance all these different interests? And so what I hear you saying is that Delaware is valuable because it's done a really good job over a long period of time balancing these interests in a way that makes it, an appealing place. I'm just curious, by the way, has it always been the place to be for, or how have other states ever been in the picture for a choice, a good place to incorporate? I mean, is there a new rising star or anything like that happening? Is this Texas threat even realistic?
Yeah, I mean, that's a great question, meaning that, ultimately Delaware, it's dominant. And it seems like it's always been that way and always will be. That being said, before Delaware, it was New Jersey, and they changed their laws in certain ways that people who were incorporating decided that it was better to travel over to Delaware and, incorporate there, or, essentially go through the incorporation process in Delaware, better put. It's one of those things where just because Delaware is dominant now, it doesn't mean that it's going to be dominant forever. Texas, Nevada, Wyoming, other places, have features to their corporate law that people end up finding attractive. And they do, ultimately attract people to incorporate there. There's a question as to what exactly is the tipping point where, Delaware loses its dominance. There's also the question of whether or not maybe even another business form might become dominant or dominant again. The business trust, for example, throughout the history of the United States has played a really important role. There's a reason why we have the antitrust law rather than competition law. And at least part of the reason why business trusts have been popular in the past is corporate laws become too onerous. Ultimately, what's happened is that people have chosen to organize their businesses as business trusts. So, ultimately, this decision might be a good thing. It might be a bad thing. People have choices, and choices ultimately are a really good thing in the United States. Maybe the Delaware Chancery Court did a great job here, maybe not. And if people don't like it, they can take the ball, so to speak, and go home, or just simply choose another state to organize their business. And that's actually a really wonderful thing.
Anat, what do you think about this reincorporation threat? Do you think that this case is going to prompt either Tesla in particular or companies in general to move outside of Delaware? Or is this actually an example of Delaware really holding the line and showing its value in a way which should maintain its dominance?
Thank you so much for this question because I've been asking myself that, and I actually just wrote 2 papers about it. One is I call the Delaware Beware because, Musk tweeted, "Beware of Delaware." And I actually said, well, actually, Delaware should be the one concerned because it has a direct threat, right? When you have an influential figure like Musk urging others, come live with me. And so I went and I checked, and I have another piece that's called "Where Do Unicorns Incorporate?" And I found that over 90% go directly to Delaware. Why is it so substantial? Because those are the other celebrity CEOs, right? The unicorns, these firms that are so unique and are private, are worth over $1 billion, and they're the next celebrities. And they still overwhelmingly pick Delaware. Now, I'll tell you why I don't think it's going to change. Because I don't think that Musk is going to prompt, right? This case is going to prompt a significant exodus. And I also sit on the American Bar Association's private equity venture capital committee. And I speak to other lawyers and I ask them, so what do you think? Where are you going to recommend your companies to incorporate? And they all say, I even, polled the room and they all say, well, Delaware. And then I try to understand, okay, why? And those were the same things that we all know. So why do companies, or why do the lawyers that incorporate these companies will stay in Delaware? There's really three things. One is predictability and expertise. The Chancery Court, the Delaware Chancery Court, is renowned for its expertise in corporate law. And so cases, especially cases like Tornetta, when you have such an influential CEO like Musk, they demonstrate the court's ability to tackle these types of nuanced governance issues, even when the person involved is such high profile like Musk, and still take it on. Second is the tailored legal standards. Delaware's corporate law provides flexibility. It allows companies to customize governance structures while holding them to fair procedural standards. And I think this balance attracts corporations that want to align governance with their unique needs. And the third is investors' credibility. Investors that invest in companies, they want credibility. They do want rigorous scrutiny. Sophisticated money wants scrutiny. They are concerned when they see conflicted transactions, even when the CEO is so influential. You know what? They might not say that publicly, but just watch what they're doing. And that is, they are still investing in companies that are incorporated in Delaware. And I think that's why I agree with Eric with the race to the top. They want this reassurance. They want to know that when they put money into companies, that their interests are going to be protected. And so and Delaware law builds trust in corporations that are incorporated in the state. And I don't think that's changing. I think, again, Delaware law enhances credibility and investor confidence. It ensures accountability for conflicts of interest, right? And let me just explain. That's when you have the same person either influencing the board or standing on the same size of the transactions. And that's why companies should actually follow this case and understand that you need to invest in robust governance practices and you need to comply with these standards. And so I actually think it will deter poorly governed firms.
Yeah, I actually don't know that I have the same degree of confidence that Anat has in terms of, the vitality of Delaware. I mean, in life, the only constant is change. Assuming this appeal reaches finality, assuming that, assuming this case reaches finality, meaning that, this opinion holds up and there are no other procedural maneuvers that can be used to undo it, ultimately there are really two options here. The first option, change the rules. There's a history of doing that in Delaware. I think the Smith v. Van Gorken case where people didn't like the rule that the court announced regarding the duty of care, and the legislature came in and said, no, we're going to undo that. And the second is to change jurisdiction. In regard to that, that is an option. I mean, there's a market for law in the United States, and one of the wonderful things about markets, they assemble information and people can make choices, and we may see that people make other choices, and there's something else that, works in the background here. I mean, Elon Musk, he takes no prisoners. He takes no prisoners on Twitter. Or X is now out. He takes no prisoners in life, and he has, now a very big role in the incoming Trump administration. The pressures we could see in all sorts of forms that we haven't even imagined, you know, could be amazing. It could be one of those things where, Delaware goes the way of New Jersey of being just sort of this note in history of, well, that's what people used to do. And, now we're going to organize in Texas or Nevada or Wyoming or Puerto Rico or who knows where, because just simply the law is better for the corporate form.
It's going to kill me. I have to just add on to that.
Go
If
ahead.
we see Elon Musk teaming up with Elizabeth Warren, right? I mean, so what Eric was alluding to is this notion to federalize corporate law, because currently corporate law changes from state to state, right? That's why Delaware is so powerful. And what if now we're going to have these calls federalize corporate law? And who's standing behind these calls? Prominent figures like Elizabeth Warren. And Elizabeth Warren, let me remind you, was going after powerful CEOs like Musk. Actually, she directly went after Musk. So I'll be damned if I'm going to see Elizabeth Warren and Musk collaborating on this issue. But who knows? Maybe I'll be surprised,
Well, I think what we want to move to next is how to help boards and corporate lawyers feel a little less surprised, because at least some people think this was a surprising decision. And, not you work a lot with practice. You're an accomplished scholar who also interfaces a lot with the practical side of law. So if you were advising boards or being, expert to corporate counsel that wanted to ask you a specialized question about how do I deal with this change? Kind of like after Smith v. Van Gorkum, people started, doing stuff. So Smith v. Van Gorkum was a case where basically a board made a really quick decision over a weekend that was a big deal. And afterwards, one of the pieces of advice was, the board members need to write their initials on every page to prove that they read it as they flip through these 800-page merger agreements. And that's what I mean by paper and process. Some of it was a little silly. And you're right. The legislature said this isn't really what we're going for here. But for now, people might change their behavior because they want to avoid this kind of issue. How should your clients or your colleagues, advise clients differently so their processes stand up to scrutiny given this case?
Thank you so much for this question. And, I used to be a transactional lawyer, and I still think as one, and I teach my students to think as transactional lawyers. And for me, especially because of these cases, again, let me think about 3 high-level issues that I will need, I think, to do if I were representing large companies in the future. And that is 1, anticipate the risk. Identify potential pitfall in conflicted transactions. And this is your job, transactional lawyer. You need to recommend the procedural safeguards. And we know paper and process helps, right? So first, you need to anticipate the risk. Second, you need to design the processes. You need to help structure the transaction to comply with Delaware's standards and mitigate legal exposure, right? And that is the paper and process. You want outside advisors, right away experts. You want everything documented. You want to make sure the correct committees are set up in place, that they're independent in the way they approve the deal. And the third is you want to strengthen the legitimacy of the vote, right? Also think about, because here we talked about the fact that the shareholders voted. Absolutely, they voted. So what do you want to do as a transactional lawyer? Think about this case and think about how you can ensure that the shareholder votes can withstand judicial scrutiny. And that is, you want to make sure there's disclosure. It was done appropriately, right? And that is, you want to have it tailored. You want it to be credible. And you want to make sure you follow the proxy rules as well. And have it as tight as possible so that you're also protecting your company from litigation. Although I will say litigation is a part of doing business. So you also need to think about the efficiency of the transaction.
Eric, do you think this will lead to more litigation? Because now there is kind of a weakness that boards may have to address and therefore a way to challenge things? Or are boards going to batten down the hatches tighten their processes and just become stronger? And, are we going to go the way of Anat and incorporate better process, or are the litigators going to have some paydays coming up?
And so I think there will be more litigation. It's one of those things where plaintiffs' attorneys like to take their shots. One of the problems with the opinion that we have from the Delaware Chancery Court is we're not sure exactly what is permissible. How much pay is exorbitant? If this had been $40 billion in compensation, is that too much? Is $30 billion, et cetera, et cetera. Second, in addition to that, we're given some sense of the process here in terms of getting approval from shareholders or ratification from shareholders, meaning approval before the transaction or ratification afterwards. But, we don't even know what exactly is permissible for what we have. And, it's one of those things where the common law system, it's a great thing because it allows the law to evolve in an organic way. But at the same time, having statutes that tell you exactly what the processes are can be really helpful because they provide certainty, which can be really useful in business. It's one of those things where improving your processes, if you are a corporate lawyer who is advising a client in Delaware, I think you have to do that. That has been stated over and over and over again in regard to the case law. There are lots of different ways to arrive at different conclusions and take different opportunities under Delaware law, but you have to follow one of the paths that the Delaware law actually establishes. So as a result of that, I think that the message here is tighten things up, maybe put pressure on the legislature to make changes to the law if there's specific things that you want clarified. And if you don't like it, well, there are a whole bunch of other jurisdictions happy for you to incorporate in if you are unhappy with Delaware.
So for the corporate lawyers and law scholars listening to this, I think an open question is, what do you think? There are different approaches, and there's certainly different perspectives, even more than we heard today, that there are signs that Delaware courts are overreaching and upturning shareholder democracy, and others that are saying Delaware is strengthening shareholder democracy through procedural integrity. So I'd be curious if people want to share their comments and thoughts below. We can continue the conversation because there are ramifications for this that are really important and could shift money around America in major ways. This could push companies to consider other states for incorporation. It could actually encourage companies to come to Delaware and keep the unicorns there, as Anat pointed out. So you can use the comments feature in this podcast to share your thoughts, and we'll continue the conversation. But for now, I just want to ask if there's any final thoughts on what has been a fantastic discussion on a 50 or apparently $100 billion question. Anat, what are your closing thoughts on this one? Key takeaways for our listeners.
To me, it's to the companies and their CEOs, get it right the first time. Adopt strong governance metrics, build trust, protect your stakeholders and shareholders, secure your long-term success. It will pay off. It really is. Process is key, not just substance, okay? Think about that. And that will serve you in the long run. And if you just hire and listen to the correct corporate lawyers, it should not be a heavy lift.
Yeah, I think sometimes businesses don't like to listen to corporate lawyers because we tell them things they don't want to hear. Like, you can't just ram this down people's throats because it won't actually work. But, then you get stuff like this happening. Eric, what are your final thoughts on this matter and key takeaways for people?
It's the best of times and it's the worst of times, to paraphrase Charles Dickens. It's the best of times in the sense that it's an exciting time for corporate law. You need to stay tuned. You need to listen to podcasts like this to figure out what's going on because things are evolving. It's healthy that that's occurring because it's balancing interests within these systems. But it's the worst of times if you're a corporate lawyer because the law's uncertain. And, business people like certainty. They want to know, once they've consulted a lawyer, is this legal? Is it not? What am I permitted to do? That uncertainty isn't great. This opinion, in one regard, this case in one regard stands for the proposition that shareholders shouldn't be taken advantage of. But it also stands for the proposition that shareholders can do what they want to do and that businesses don't really know what's permissible. So as a result of that, we're going to be talking about this for a while. And it's one of those things where we're going to see courts trying to struggle with these issues. And that's going to be fascinating for us academics, but it's going to create a lot of challenges in business.
So I've been tweeting at Musk over and over again, just give me a call. This could have been resolved a long time ago, less messy. Think about deal making, right? We also have Trump coming into power. Trump loves deal making. And I like to think in those terms as well. And that is closed deal. And I kept tweeting at Musk saying, just give me a call. We can resolve this. You can do certain things. And I say that to CEOs and I say that listen to your corporate attorneys. Use processes. You can make your life much easier and you can get what you want at the end. But that's just my 2 cents as a corporate lawyer. That's how I think.
Hey, if there's one thing all corporate lawyers will agree to, it's that you should listen to your corporate lawyer, right?
Absolutely.
So on that note, thanks to both of you. Thanks for our listeners. And until next time, we'll keep asking the big questions in law and leadership, and we'll see you for the next episode. Thanks.
Thank you for having us.
Thank you.